If you truly respect the women in your life, as I do, then you're angry at the media's abject failure to explore the so-called rape and incest exceptions that candidate Romney recently made part of his abortion policy. How would those work exactly? Picture your sister or your daughter, your wife, your girlfriend, any woman in your circle sitting in a courtroom next to her lawyer. A bailiff instructs them to stand, and a judge enters, and he ascends the bench, and he peers over his one-page decision, and he says to her, "I find that you have failed to prove that you are the victim of a forcible or otherwise legitimate rape, as our legislature has defined those terms. Therefore, I must deny you permission to terminate your pregnancy and warn you that any effort to procure an abortion may constitute attempted murder." The woman you know is devastated, understandably, because she has just been condemned to bear the child of her rapist. But as he descends from the bench, the judge attempts to console her, saying, in the animating spirit of the new law, "My dear, try to think of this as God's will." You tell yourself that this could never happen to any woman I know, and you are wrong. Justice Department crime data show that over 250,000 American women are sexually assaulted every year. Statistically speaking, that means that 1 in 5 women will be sexually assaulted in her lifetime. And every year, over 30,000 women will become pregnant as a result, according to the American Journal of Obstetrics and Gynecology. Many experts also concur that at least as many rapes and pregnancies go unreported because the perpetrator was a family member or a friend, or the victim was simply so frightened and ashamed that she never contacted law enforcement. Rape and incest are legal determinations, not medical ones. So would a sworn affidavit saying "I was raped" suffice? If more is required, who makes the decision and how? Is it a full-blown civil proceeding brought by the victim herself, where the standard of proof is by a preponderance of the evidence? That is, she more likely than not was raped? Or must the victim await a guilty verdict in her rapist criminal trial before she can terminate the resulting pregnancy? What if the rapist is never identified? What if he's identified but never caught and tried? In such cases, must the victim rely exclusively on an elected prosecutor or judge to exercise their discretion in granting her permission to terminate her pregnancy? On the other hand, if the accused is acquitted in his criminal trial, where the standard of proof is beyond a reasonable doubt, but found liable in a civil proceeding brought by his victim under a lower standard of proof, just like O.J. Simpson was, is that enough to trigger the rape exception? Must the victim have actively resisted and show signs of a struggle or some physical injury to prove the forcible or legitimate nature of the rape? Is the rape exception determination process accelerated to ensure that a decision is issued before fetal viability? Is there a right to appeal? If a decision granting a victim permission to terminate it is issued in the 3rd trimester, or God forbid, within weeks or days of full term, what then? And perhaps most disturbing of all, what parental rights does the perpetrator have in the child of his victim, who was forced to give birth simply because a fallible and overburdened justice system decided wrongly or too late? Any rape or incest exception is unworkable, unbearably intrusive, and in the end, a cynical ploy to comfort those who oppose abortion in principle, but cannot bring themselves to ban it absolutely. In the next 4 years, at least 1 million American women will be sexually assaulted, and at least 120,000 of them will become pregnant as a result. A vote for Mitt Romney is a vote to deprive those women of the basic right to self-determination and legal equality that you probably take for granted because you have a penis. So grow some balls too and stand up for the women in your life. Don't vote for Mitt Romney.